Yeah, all right. Okay, so we are rolling, and officially welcome everyone to this afternoon's Fire Faculty Network webinar. I am Peter Bonilla. I am Vice President of Programs at the Foundation for Individual Rights in Education, where, among other things, I oversee most of our faculty programming and faculty development, including for the last year and a half or so, these webinars that we've done on occasion with colleagues of mine from FIRE and faculty guests from various institutions. I'm really excited to get to this to today's discussion, but before we go, I just want to give a couple of brief announcements for attendees here. Firstly, we are hopefully in the next week or so going to put out the call for proposals for our fall academic conference, which we are still in the process of nailing down the dates on, but should be sometime this October, November, as they tend to be. And I will send an announcement out to our faculty network listserv when all that information is up and current. So stay tuned for that. And we have also, in the last handful of days, put this information on our website, rolled out a small new program of ours. We have launched a small events fund for our faculty network members, and how this works is, and I'm going to send it to the chat here. This is a new initiative of ours that gives small grants to faculty doing free speech, free expression, academic freedom related activities at their campuses. Not money to change your life, but small amounts up to about $500 that can make it hopefully just that little bit easier for you to round out the resources that you need to be able to pursue your programming on your campus. Information at the link that I've sent to the chat, and I'm very happy to take questions from anyone interested in availing themselves of the fund or applying for funding for their programming. So information at the link. Happy to talk about it by email outside this meeting. And I think those are my announcements. So I'm going to get to today's discussion, and it is a topic that I am really excited to be discussing in this webinar of ours. It's the intersection of the academy and public records laws, a very fascinating issue of the law, in part because it raises very serious, very compelling interests, both in the areas of transparency and public accountability, and also academic freedom and research integrity and things like this. It's a difficult, complicated issue, one that FIRE has gotten more and more involved in, and in an area that FIRE has availed ourselves of more and more in terms of taking advantage of public records laws. I had a colleague of mine do a quick survey on these laws to see just how many times we used them in our work last year, and he got back to me saying probably about 75, but almost that was surely an undercount, and that it doesn't include a number of large-scale projects we have going on that involve submitting public records requests to a couple of hundred institutions at a time. So it's something that we have used regularly in our own work. It's something that we have pursued litigation involving. I'll send a couple of stories to the chat as we go, but we have at FIRE have filed a number of these public records lawsuits when universities aren't holding up their end of their obligations when it comes to transparency. But at the same time, we have repeatedly over the years raised concern over the potential for public records laws to chill academic freedom, to chill research, to intimidate and harass professors. It's a double-edged sword, like I said, with compelling interests on both sides of the issue. And that's what we're here to discuss today. And that's why I am so excited to have today's two panelists with us. Speaking first, we will have Erin Coyle, who is an associate professor of journalism at Temple University, and she will be followed by my longtime FIRE colleague, Zach Greenberg, an attorney and a senior program officer with our individual rights defense program. Erin, Zach, thanks very much both for joining us. And Erin, maybe since I imagine we're going to have no shortage of questions and no shortage of conversation topics to be discussing. I'm gonna hand it right to you. And just quickly before I do that, I will tell our attendees, the chat should be open for you to add your questions. So feel free to do them in the course of the discussion, and we'll get to as many of them as we can. So thanks, and Erin, please take it away.
Great. Thank you very much for joining us today, and thank you for the opportunity to talk about a subject that I love very much. I do want to make very clear that I am not a lawyer, but I am somebody who loves open records laws. I have used them as a journalist and also as a researcher, and as a teacher, I teach my students how to write open records requests and seek documents. These laws can be wonderful. They can be great tools for us to try to use. And they do vary in what they do and do not cover. Just to be clear, first of all, every state in the United States has its own open records laws, and their titles can vary quite a bit as well. Some of them are called Freedom of Information laws. Some of them are called right to know laws. Some of them are called public records laws. And learning that jargon helps us for trying to even find what those laws are. They vary from state to state, and they vary in their focus. So one of the things that can help us when we're trying to figure out how to use those laws is to try to find them and read through the purpose of the laws. Many of them are written because they are intended to allow citizens to access information about how government agencies are doing their jobs. Now, what a government agency is may be a term of art and also can vary from state to state. Some states' laws only cover executive agencies, and the extent to which public universities may be covered by these laws can vary as well. Okay. So first, there are lots of questions for what may be covered, what may not be covered. When may we, as employees for universities, be subject to having our work requested under these laws? And when may we have to provide that information? Okay. It's also important to note that these laws can be helpful for us as well. They can be tools for us to be able to gather very useful information. For example, in some states, salary information is publicly available. So if you're at a point in your career at which you could be negotiating a salary bump, or if you have a job offer, it can be very helpful to do a public records request for the salaries of the people who are working in the department or school that you're working in, or asking for the range or the average of people at a similar rank within the school you are in. The institution I currently work for is not subject to Pennsylvania's open records law, which is called the right to know law, the same way that some other state institutions are subject to the law. So when it came time to negotiate salary coming to this university, I was instructed that while I wouldn't be able to get that information under an open records law, I could contact the union, and the union would have that information. So sometimes it really helps to talk with people who are your colleagues or who are more knowledgeable about the institutions where you've been, to see if the information isn't available under an open records law, it might be available another way. Okay. But we don't always have to sit down and write formal letters explaining the name of the law and the citation of the law to be able to access public records. In some states, even walking up to someone and asking for a copy of an open record is considered a formal open records request under state law that would have to be responded to. Okay? Now, the time periods for responses can vary greatly. Sometimes it's 5 business days, sometimes it's 10 business days, sometimes they don't actually have numbers to help us out. They have something such as the wording of a prompt response, and what that means can vary. Right? But it's important for us to know whether we are subject to these laws or not, and what types of our own materials may be subject to them. Okay? You may be wondering about teaching materials. What about exams? If it's an exam that you plan to use again, in some states, there are clear exemptions within the open records laws that will state those exams will not be considered public records that have to be released. Okay. There are some trends lately in people seeking information about student conduct code violations using open records laws. And then we get into questions about not only what may be released under a state open records law, we get into the question of what has to be withheld under FERPA. Okay. And FERPA does have very clear language related to student disciplinary records. In a recent case from North Carolina, members of the media had asked for the names of all people who had been found responsible for rape or sexual assault through student conduct code hearings. Okay? And as the case went through the court system, we learned more. And ultimately, we received an interpretation of FERPA stating that under FERPA, the university did not have to withhold the names of people who were found responsible, okay, what they were found to have committed, and what punishments were imposed. Okay. But FERPA also has very serious limitations on what may or may not be disclosed. In fact, we probably receive more information about FERPA than we do about open records laws in the academy, at least learning that we have to be very careful not to release student identifying information and their grades or other similarly sensitive information. But FERPA is not the only protection that could shield some of that information. Many state open records laws also have privacy exemptions that cover personal information or confidential information. And that's important for us to know about so that we are very careful with any information that students might provide to us, whether it's information about medical conditions or their personal lives, whether they tell that to us in person or hand us a medical provider's note or send it via email. We need to be very careful with that information because in many states that would clearly be exempt from being released under an open records law. But there are lots of questions about our communications, especially our emails, for what types of information could be available to the public under open records laws. And again, that can vary state by state. There is case law that clarifies some trends for us. One is that if our emails are directly addressing the university and its policies or working conditions, okay, then that's the type of information that many public records laws are intended to be able to shed light on. But on the other hand, if it's deeply personal information about our own lives or someone else's life that doesn't shed any light on how the university is doing its job, okay, then that type of information is not likely to need to be released under an open records law. In fact, it might fall under a privacy exemption. There have been some trends in cases addressing some government employees' attempts to get around public records laws by using their own personal laptops or cell phones or other electronic devices. And it's really important for us to know that the trend across those cases show that if our subject matter is about what a university's business is, those emails or text messages may still be subject to release under an open records law, even if the communications happened via personal devices or even on personal time. Okay. So when I start talking about what do we need to release, what don't we need to be released, I think there are a lot more questions about that than there used to be, because there have been some trends lately for researchers to receive public records requests that ask for vast amounts of data specifically related to their research. And then it becomes very challenging to figure out what do we need to release or not release. And some of this will depend on universities themselves for whether we as professors or faculty members are responsible for gathering and releasing that information ourselves, or whether we are responsible for finding out who within the university handles these types of requests to make sure that we are complying with them properly. Okay. But in some cases, people have been asked to turn over thousands of documents at a time. And we have to think very carefully about if we have gathered personal information about research participants and promised that we would not release data with their identification on it, how can we meet all of our responsibilities? And that's where hopefully you could go to university counsel for guidance on exactly what to do for following both laws that would be at play. Okay. One other thing I'd like to bring up is that it can be very helpful sometimes for us to write public records requests. And one of the secrets to doing a really good job writing a public records request is to do research before writing that request. To do some searches in some states, attorney general's offices will have opinions available online that explain previous advice that they have given to open records requesters about the types of information that may be subject to release under open records laws. Those are very helpful for us to look at. I'm in a state that has another type of open records office that also gives advisory opinions, and we can browse those online. We also can contact these offices ourselves and ask them questions. Okay? If you're on a friendly basis with the people you think might have the information you're interested in, it can also be really helpful to have a conversation, asking them a little bit about the types of information that may be available, the formats that information is in, getting as much information as we can to provide a really specific request about exactly what we're asking for. If we're asking for copies of emails, if we say, this is the name of the person who sent the email, and this is the name of the person who received the email, in addition to giving email addresses, can be very helpful. We also can say, here are certain keywords that need to be included in the emails to narrow the parameters. And also giving specific timeframes can help to narrow our requests. Well, it's important to write as clear and narrow of requests as we can, because it's harder to deny those requests. If we give very large, unwieldy requests that are so burdensome that they are hard to fulfill, in some states, our requests may be denied simply because they were considered burdensome. Okay. It's also important for us to send that formal written request once and get it right the first time, because under some state laws, our requests also can be denied if we send more than one request as being a repeated request, right? So all of this is about respecting the resources of the agencies that handle these types of requests, right? But I see a mention of FOIA, the Federal Freedom of Information Law, in the chat. And that reminds me of one other very important point. Please be sure to cite the correct law, right? The Federal Freedom of Information Act pertains to records that are held by federal executive agencies. Okay? The state Freedom of Information type laws, what are also often called FOILs, okay? Those can pertain to state agencies, which in some states will include public universities and colleges and public community colleges, okay? As well as state, county, parish, or municipal agencies. It's important to have an idea of the breadth of who might be covered by these types of laws. As we go through our careers, we might think about applying for grants from cities, states, or the federal government. And when working on those applications, it's worth doing a little bit of research to find out what information will become available under state or federal open records laws if we apply for those grants, and especially if we receive those grants.
If I might just real quickly, at the outset, I said people with questions. I think I accidentally said you can send them into the chat. I was directing them to the wrong place. The best place to send any questions is to the Q&A, which I think should be open. I think people should be able to oh, and I see one has just come in there. So yes, it's open, it's working, but apologies for earlier. That is the best place to send any questions. And like I said, we'll do our best to answer them all for you. Erin, did you have more, or were you about to hand it over?
Well, I see one mention of a very expensive bill being mentioned in the chat, which brings up one other important point. To think carefully about, if you have a budget for your requests, what that is, because these laws often will allow for us to be charged for copies. Now, sometimes we may ask an agency to have records be made available for us to come in and scan ourselves or photograph ourselves, and then get around having to pay fees. Okay? But it's really important to know yourself, how much can you pay when you're seeking these types of materials? Do you have any support to help cover the cost of copies? You can request fee waivers in your letters, or you can put in, this is the most I'm willing to pay, please contact me and let me know if it is going to cost more than this.
Erin, should I hand it over to Zach now?
Yes, thank you very much.
Okay, great. Zach, I'm ready to hand it over to you, and I see we've had some questions come in already, which is great. That's why I gave this session an hour and 15 minutes as opposed to the usual hour, because I had a feeling people would come armed with good questions. So Zach, please feel free to take your part away.
Sure. Thanks, Peter. And thank you, Erin, for that wonderful introduction and walkthrough for public records laws, open records laws, and some tips and tricks on how to make these requests the best they can be. It's an honor to serve as on the same panel as a media law expert and press freedom expert. It's great to be here and great to talk to you all on the chat here, coming from FIRE's offices in always sunny Philadelphia. I'm a First Amendment attorney. I deal with a lot of students, student groups, and professors, especially when it comes to academic freedom. And I just want to talk briefly about academic freedom, how it interacts with open records laws, and what the interests here that how they conflict and how we can resolve this conflict and have both the transparency afforded by open records laws as well as the right to pursue research, teaching, and debate that's covered by academic freedom. So just as a quick introduction, academic freedom, it has many definitions. It's been, I guess, batted around over the years what exactly academic freedom means. But for starters, academic freedom in FAR's perspective is a general recognition that professors must be free to teach, research, and debate ideas without censorship or outside interference. And this is really important to the professors that FIRE works with because many delve into these controversial and unpopular issues on campus, whether it's teaching in their classes about hot button political societal issues, whether it's their research, whether it's speaking in their capacity as experts on the subject matters of their fields. And our goal here is to protect academic freedom by defending professors when this right's under attack. And this can conflict with open records laws because although open records laws are really useful in terms of requesting information from universities and of course from governments, public universities that is, they can also be used to target professors for their expression and their research and their pedagogy. For example, we've seen over the years professors involved in religious liberty jurisprudence being targeted by LGBT groups. This usually comes in the form of a professor speaking out on behalf of a controversial viewpoint, and then they get a request from an outside group targeting a large array of their personal information, such as phone records, private emails, travel documents, and there's really no effort to engage the professor. It's more of imposing a burden upon him or her for speaking out. We've seen this happen with political parties. I believe it was the Wisconsin Republican Party targeted a professor at University of Wisconsin for an article he wrote in the New York Times. Was critical of the party. And the request was very transparent. It wanted all information regarding the words GOP, union, Scott Walker, collective bargaining, stuff like that. And a lot of these requests are very much attempts to deter the professor from speaking out. We have no desire to get information, rather to burden the professor and to retaliate against the professor for criticizing these institutions. And this is a really tricky issue because open records laws, like Erin so wonderfully discussed, are a really important tool for getting information from universities. The one thing that FIRE does not want to do is blunt the effect of open records laws, these sunshine statutes that reveal the inner machinery of higher education. As Justice Louis Brandeis came out and said, it's the best disinfectant here. And this has been proven true throughout the history of open records laws. Just in the past couple of decades, we've seen open records laws being used against universities to really reveal some of the worst scandals in higher education. From the clout list at the University of Illinois, where it was discovered using open records laws, the Chicago Tribune, that the university was accepting hundreds of subpar applicants because of the interference of university trustees and other state lawmakers. And it resulted in the university president, almost every trustee, all resigning. And this was used, it shows the power of these laws to really unearth these scandals. Other ones involve ESPN using these laws to figure out at the Ohio State University that administrators were seeking student athletes to receive tattoos in exchange for signed memorabilia. Also, CNN uses them to figure out at many universities that they have really ignored athletic requirements and grade requirements for student athletes, allowing many of these athletes to persist in university without meeting the standards here. And these are some of the examples of how these laws are used in higher education to really figure out what's happening here and to shed light on higher education. At the same time, though, when they are used to against professors to stifle debate and to really punish them for the advocacy, FIRE will step in and we will write articles, we'll defend the professor, we'll point out that these laws are, the invocation of these laws are chilling, that instead of creating more debate and dialogue and discussion, instead of responding with speech you don't like with more speech, these laws are used to really harass and burden the professors, to really delve into their private information here, go on fishing expeditions into their private lives. One thing we see very commonly is these laws used against professors to get their unpublished research, their untaught lesson plans, their private emails, and the travel records and phone records. Really nothing to do with any newsworthy information here, but rather information that the professor would be embarrassed to reveal because it's not finished yet or it's not ready for publication. I'm sure you know that the writing process is very fraught with stops and starts and can be a very long journey, and to have to disclose to the public your unfinished writings and to have to have the public watching over your shoulder and seeing what you do all the time can be a very daunting ordeal for many researchers. So what FIRE does, and we propose, is that we have a very limited and narrow exception to open records laws that we lobby states to adopt. And want to repeat that we don't want to blunt the salutary effect of open records laws. We don't want to make universities immune from these laws. Our goal is to allow these laws to have their sunshine-inducing effect while protecting academic freedom. And our exemption here, which is on our website, essentially exempts from public disclosure the faculty records that had the purpose of concerning research and scholarship and teaching classroom activities that really are the core of a professor's job description, the essential parts of their academic freedom right to engage as scholars in their chosen fields. And of course, we don't want to exempt administrative records. You don't want to exempt information regarding university affairs. This really only targets, for example, data, records, information, research notes, proposals regarding commercial, scientific, technical, scholarly articles or issues. So the goal here is really to ensure that university affairs, public university affairs that are bound by open records laws, that they remain open and transparent, that the university community and the public knows what's happening in these institutions that are spending sometimes billions of dollars of taxpayer monies. At the same time, protecting professors who are working there, who are technically government employees, and who have a very important role in the research and teaching and debate, which the process of which and creating which would be better done in private. And so our exemption and our advocacy here really focuses on protecting academic freedom, protecting the wide range and the overall goal of open records laws, and our efforts to lobby legislatures to adopt it into their statutes. As Erin helpfully stated, almost every state has different rules when it comes to how open records laws affect professional and government employees. Some states exempt colleges in total. They just don't allow people to submit the records requests to colleges. If you submit them, they'll reject you out of hand. Other states do a really good protection for government employees, especially for professors and others engaged in these proprietary industries, protecting their research, their debate, their teaching, their private records. In some states, it's very vague. Some states, it's kind of left up to the interpretation of courts and open records arbiters, which really leaves the professors kind of hanging in the wind here. Without clear rules that delineate the limits of open records laws and how they affect academic freedom, professors could be on the hook for fighting these at the university level. The university could misinterpret them to release a large array of private records that have no newsworthy value. And at FIRE, we always advocate for these laws to show or to have a purposeful exemption and purposeful, different sections regarding how they interact with university personnel, university professors. So that's kind of our gist when it comes to open records laws and academic freedom. It's an interesting issue because these are both extremely important factors in our society. It's a very rare circumstance where these rights conflict and these issues really conflict here. And our goal is to resolve the conflict. We don't want to have situations where open records requests for newsworthy information are denied, and we don't want to see professors stifled from research and teaching and debate and from speaking out because they're overburdened with with open records laws. So with that being said, turn it back over to Erin and Peter, and it looks like we have a bunch of questions as well.
We have we've definitely had a number of questions coming in, and thanks everyone who has been sending them. You know, as I told you privately before, if either of you have questions that you'd like to take the other one up on to get a sense of their own expertise on, Zach and Erin, I'm very happy to hear that as well. But I am, yes. Let me see. I guess I'll start with a question for both of you to get things going. You know, Erin, you have been a scholar in this field for a while. You've done a lot of research on public records law. You've I also imagine you know, taught a lot of others and given instruction and guidance to a lot of students on this. Zach, you've been an attorney with FIRE for several years now, and you've spent most of you spent pretty much most of that time in our individual rights defense program. So, you know, investigating and writing letters in these cases as they come in. I guess an opening question from me to both of you is, if in your years doing this work, if you've seen any kind of change in the climate on public records generally, but really as relates to higher education, sort of, you know, they're, you know, looking at things today, you know, there's, you know, in terms of things like, you know, to take one example, you know, any of the many bills on critical race theory in K-12 education or higher education, a lot of them make a very big deal out of making certain materials, syllabi, you know, course material checklists more transparent. At the same time, there's, you know, any number of instances where we've seen an appetite for making certain information, say having to do with presidential searches in higher education, things like that, you know, less hard to get your hands on. So I would be curious for both of your takes on sort of where you see things going and how things might have changed from your standpoint over the last few years.
Erin, if you want, you can go first.
Well, I think this is an area where I see both sides of the issue. On one hand, I see the importance of transparency for how well the education system is working. And I think those requests related to candidates for university presidents and chancellors relates to looking at the organization of the university for how it's working and how the administration is working. But part of what I'm seeing more attention being given to are the challenges that Zach has been talking about with faculty members receiving more and more requests related to their research. I can find cases going back even to the 90s with people doing public records requests to ask about how animals were or were not used in research in labs. But I think we're finding a broader variety of types of requests. Oftentimes singling out particular professors based on their research or based on comments that they have made publicly, whether it be via media or via social media. So I'm seeing more instances of not only requests for professors' research, but other materials as well, asking for all of the teaching materials, asking for all of the syllabi for any of the courses that they have ever taught. And there can be questions then about which of those records actually should be public records. I think it's pretty clear that course syllabi would be considered to be public records. There's even case law in New York addressing that if we have reading lists for students or syllabi, that those would clearly be considered public records there. But it's really interesting seeing whether states have adopted specific statutory language or whether they have interpretations of statutory language. New Jersey's Office of Open Records has an interpretation of what may be exempt under New Jersey's law, which I think speaks a little bit to the breadth of what types of information is being requested now. Would you like me to tell you what it is? I'll read it to you to make sure I get it correct. Okay. They would allow for exempting pedagogical, scholarly, and or academic research records and or the specific details of any research project conducted under the auspices of a higher education institution in New Jersey. Okay. So having pedagogical there, in addition to scholarly, really widens that umbrella for giving faculty more protection. But I think the other side of me that really wants more transparency would hope that that is not interpreted in a way that it could hide curricular information.
Thank you, Erin. Zach, your thoughts?
Yeah, that's exactly, hits the nail exactly on the head. I'm reminded of, I believe it was a proposed state law that would require all grade school curricula and reading lists to be public information, some sort of educational transparency bill. And it was controversial because, if I'm not mistaken, the ACLU actually came out against it. They said, no, this information should be private. It should be up to the educators to determine this and not based on public scrutiny. And it's really interesting because whenever we look at these situations where there are conflicting rights here, in this case, pedagogical privacy and transparency, government transparency, you got to think of what are the interests that underlie each of the rights. And like Erin touched upon, something like a public university presidential search committee, these institutions are largely government agencies. A lot of them, they're under the state apparatus. If you submit a open record request, then it goes right to the attorney general or to someone in his or her office that does this kind of stuff. So when you think about it that way, who should lead this billion-dollar public institution? That seems to be a pretty public decision that should be open to the public and have that kind of transparency there. But we're talking about curricular decisions of the individual teacher or faculty member on the base, the lowest possible level here. That does implicate privacy and academic freedom. There is a stronger interest there. That's why when it comes to administrative records, there's really very few exemptions for what can be requested. Whether it's budgetary records or personnel records, really how those operations are run and what their inner workings are. So in terms of trends, to answer Peter's question, we are seeing a lot of student journalists use open records laws to get more information about their institutions. I'm sure that's a in small part to Erin, all the other media professors out there who are training the students very well and helping them be the best journalists they could be. We're seeing more of that. It's definitely a tool in their arsenal. It's becoming a more widespread news gathering tool. We're also seeing many universities stonewalling journalists, of course. The flip side of that is universities saying, no, you can't have these records X, Y, and Z, or we don't recognize you as a journalist here. And so we're seeing some litigation here. We're seeing some institutions, and FIRE included, that do sue universities that unlawfully withhold open records laws that are being that don't interpret the law correctly, that are being stubborn and being non-transparent when it comes to how these laws are enforced. So we're seeing these laws getting more traction here when it comes to societal parlance and how they're viewed. And I think the debate over transparency and pedagogical privacy in higher education and the grade school level is becoming more in the forefront of the public's mind. And as these bills are come out, and as debates about critical race theory, or whatever people want to describe that as, and how it's taught in schools, what's taught in schools and what's taught in higher education becomes more pronounced, I think we will see a greater use of these laws, and it'll be interesting how universities respond to them.
Great, thank you both. Yeah, I'll add just 2 cents to that on the issue of higher education curricula and syllabi, which is it's an interesting area, and one that I know I've been a part of some discussions at FIRE over, when we see laws proposed. I can't remember if any have actually passed that would force these out into the open, but we've had laws debated that would make the syllabi at public universities public records subject to disclosure. And I know we've debated the potential ups and downs of such legislation, because on the one hand, it's easy to see how that could have some potential chilling effect, but at the same time, that's the kind of information that you, especially if you're a student considering taking a course at an institution, is in your interest to know, and you should be able to get your hands on easily, quickly, and for free. These are there's a separate question of how necessary these are, because a lot of university departments make this available to students on demand, and have policies that require their faculty to make sure that they provide it, so that students can do their research. So that's an interesting area that we have, I know, had some discussions on within FIRE. I can only imagine our legislative team has had a lot more of them. And so thank you. I am going to let's see. We had a question come into the chat earlier about organizations that sue state and federal agencies for refusing to release public records as they're required to under FOIA or the applicable state law. The question, do we run into such refusals with any frequency? I would say yes. Zach can speak on this to a better extent than I can, but I know at least 2 or 3 times FIRE has sued institutions for not complying with their obligations under public records laws, and I have those tabs open, and I can send those to the chat. But I guess maybe Zach, could you give a kind of top-down perspective?
Yeah,
how effective are these? How often do we get this kind of pushback? I feel like the most common I feel like we are more like, when they aren't fulfilled, we're more apt to not get any response at all than to get a non-response.
Yeah, I mean, universities can do several options. They receive an open record request. They can grant the request in full. They can deny the request partially. They can request fees. They can ignore it. And FIRE sees a lot of the last option, where we send a request and the state statute says it has to be completed in sometimes a matter of a couple of days. Like that, we have to get at least a response saying we acknowledge your request in, say, like 48 hours or so, or like a week. And we get nothing for months and months and months and months. And these are newsworthy stories here. We're trying to get information regarding fast-moving instances of university discipline or policies being enacted that can restrict free speech and academic freedom. To get more information about the inner workings of violations of students' rights and free speech. And so when we ask for these requests in January, we don't get an answer until July, August, September. That's not good enough. And sometimes we don't get an answer until then or past then. And so there's laws and court cases that construe the constructive delay as a denial, that if the government does not get back to us in 6 months, we can assume that, look, they're not never going to get back to us here, that they're not essentially backed up. They see a request, but we're in the garbage. Like, we get it. It happens a lot. So our goal here is to get universities to comply with the law, is to simply hold them to their promises. And if they say that we'll get back to you in a matter of a week. We expect a response. And the response can be, we request money for these documents. We want to narrow the request, want to work with them. We're happy to work with the university to make our request, like Erin was saying, doable, to make sure it is narrow and specific and that does not impose an undue burden on faculty. So our goal is to get the information that we can. And like Peter posted in the chat, we got Tarleton State University, UCLA, California universities in particular have been very bad when it comes to responding to requests. And Essex County Community College, I believe that's in New Jersey, really close to Philadelphia, that simply just never got back to us and denied our requests over and over again. So this has been an ongoing issue with us. And, we hope that each time we do this litigation, it will create an effect where other professors and other students and groups are more confident in their ability to request these records. And it's kind of a more of a deterrence factor for universities who may be bad actors that will reject the requests of organizations that will not be able to sue like FIRE can.
Zach, I wonder if part of the bigger problem there, I don't know how you fix this, at least not without a lot of time and a lot of money and a lot of lawyers, but I feel like part of the problem there is that there just isn't very much fear on the part of public institutions of meaningful consequences when they don't follow the law.
Yeah, behavior that's rewarded will be repeated. It's simply a matter of universities understanding that the risk here of perhaps not disclosing this information is very little, and that they have really nothing to lose by stonewalling us, which is why we like to engage litigation, which a lot of times will result in attorney's fees and will result in the university being kind of on watch by the courts and by the public for being a bad actor here and for repeatedly violating the law. So we like to do this in fact litigation. We like to highlight these abuses to bring attention to what we perceive as an injustice here at universities, not being transparent, not showing the public what they're all about, and by ignoring the law. Yeah, you're right. It will take a long time, take a lot of lawyers. These institutions are billion-dollar institutions. They have full legal departments. They hire the biggest law firms in town. But the law is on our side here. And if the law says you got to do something, if the law requires universities to disclose the records, we want to hold them to that.
Thank you. I'm going to go to another of the questions that we've had come in. One of our viewers asked, is there readily available an extensive compilation of what can be considered extremely intrusive or abusive open records requests for the research records of faculty members at public universities? And if there is, could you provide a specific reference to it? Zach, I think your research on this has probably set you up pretty well for that.
Yeah, my article links to a bunch of other surveys and other articles out there that do have a 50-state breakdown of open record requests. Peter linked in the chat, the Porters Committee for Porters Committee. They have also a good resource about this. The Student Press Law Center has good resources about this. Yeah, there's definitely been a lot. There's definitely a lot out there when it comes to what specific records are available by state. And I'm sure Erin can talk more about that and how each state's different, and how looking up these rules and these statutes and tailoring your request accordingly is so important here.
And there are two organizations that I just recently learned about that do seem to keep track of this. One is the Climate Science Legal Defense Fund. And they have a research protection guide that they have put together. And also the Center for Science and Democracy has a report that they have put together that do address these concerns. And they have some examples as well of researchers who have had, it sounds like, very broad requests for their research.
It makes sense that we would have it in this area, because I think in my experience in all of my years of FIRE, and I've been here for 14 of them now, probably climate science is one of the areas most ripe for public records, for public records requests of faculty generally, but also, it exemplifies more than most areas the potential with which they can be they can be used to, to chill the academic climate. So that's really good to know. And I will, thank you, Zach, for sending that to the chat. Great. Let me see. We've still got some time and some more questions. I'm going to go to one we had come in earlier. Question from one of our viewers: have there been any upticks or emergent trends regarding students requesting their own records and all other communications, such as emails between administrators, interdepartmental meeting minutes, etc., as part of potential or pending legal action? Zach, any insight there from FIRE's work?
I'll just speak briefly and then turn it over to Erin. So FERPA is the Student Privacy and Access Statute. It allows students to request copies of their records, or I guess request the ability to inspect their records. They don't want to provide copies to them. It also requires universities to retain the privacy of student educational records if they are subject to disclosure through open records laws. So yeah, we do see an uptake of students who are facing discipline, for example, or conducting litigation against the university, using FERPA to request copies of their own records. I think it's a good idea. I think students should be able to see what information the university has on them. FERPA was created in response to allegedly Richard Nixon using having these secret government files on his enemies, using this private information to kind of be to use this information to advance his own career. And so FERPA is designed to protect student privacy and allow them to access their records and allow the university to hold these records and kind of so students are able to really see what the university has on them, disciplinary and otherwise. So yeah, we do see the students using these laws to get their records, and lots of us know what FERPA is, but we encourage them to reach out to FIRE, reach out to the Press Law Center, and learn more about how they can get copies of their records.
Thank you, Erin. We had one come in for you, and I wanted to make sure that we didn't neglect it. One of our viewers says, if I understood correctly, a professor at a public university could be compelled to release emails on their own private accounts separate from university resources. Could you elaborate? Which organizations could compel me to release such emails? Would it be my employer? Would it be my university? Would it be through a subpoena? What would happen if I decline? That's sort of a lot there, but it really gets to a very important question of just what it looks like when the gears start turning into motion, and what obligations it creates for a professor dealing with one of these requests. So maybe Erin, could you take a shot at helping us out there?
So I've seen some cases that have addressed, actually usually city employees in municipalities, who are accused of engaging in communications on their personal devices to get around public records laws or to get around open meetings laws. So those cases in certain states have set precedents that if you have a government employee using a personal device for communications, and those communications are about public business, the communications may still be subject to having to be disclosed under the open records laws. Now, the rest of the questions are really, really good. And I don't know how it's going to work. Some of that will depend on the university for who's involved, and they may ask you to turn over your accounts for somebody to search them, or it would be better if they ask you to search it yourself. Other than that, it'll take a lot of our time if we have to do that ourselves. But instead, for the sake of privacy, it would be better if we get to search our email ourselves and turn it over. Universities may have policies addressing state open laws. I started doing just a little bit of searching and found Central Michigan University has some things online that explain exactly how public records requests are handled there and who's responsible for them. And not only says where the public records requests have to go to within the university, but it's going to have to whittle down to who actually has that information, who can compile the information to send it to the university for an official who actually handles the requests of the universities to decide what has to be disclosed and what doesn't have to be disclosed. That question also mentions subpoenas. Okay. And subpoenas can bring up some different issues when it comes to research. Subpoenas can reach some things that public records laws cannot reach. And sometimes when we are working with really sensitive topics and we are promising to only have de-identified data and not identify the people who we are interviewing or surveying, we have to be really careful about how we do that, because a subpoena might be able to reach more than our de-identified data set. I only know of one mechanism of potentially protecting confidentiality even against subpoenas, and that is the Federal Certificate of Confidentiality.
I've realized that I have a question that could be answered maybe by both of you. Both of you might have thoughts on this, but I find myself wondering something. When it comes to public records requests made for the records of a professor, emails, research notes, whatever, they don't generally come into the professor. They come into their institution, and there is, theoretically, there's a lot that an institution can do to manage or comply with these sorts of requests without necessarily the faculty member knowing what is being done behind the scenes to accommodate those requests. A question for both of you, and again, there are probably a lot of different answers to this depending on your jurisdiction, what state you're in. But look, what obligations does an institution have to be transparent with its faculty about requests that they receive for their faculty's records?
That's a really good question. I don't know. I think off the top of my head, I would say that it's a matter of institutional policy. I don't think state law really has a lot to say about how the institution responds to the requests vis-a-vis contact individuals regarding the request. I think it's really just a matter between the requester and the requestee here, instead of third parties. I assume maybe there's some state out there that has an opposite rule. But yeah, some universities have policies where if the request does mention specific professors by name, they have to be alerted to it, have to be within the process or whatnot. Other universities kind of have a separate office of just open record requesters that responders that really just work with the request and kind of figure out what to do here, kind of at their full discretion, whether they alert the professor or not. And sometimes these policies are not publicly available. A lot of the time, just internal departmental guidebooks and memos about how to deal with these requests. So a lot of what FIRA does, we like to FOIA the FOIA, kind of figure out like how the universities do process these requests, what is their operations and how they respond to them, to figure out what's happening here, their mechanisms, their process. And that's really interesting to us because we can use that information to better tell our requests in the future and figure out how to best get the information we need. But to answer your question, I think it really just depends by institution. And Erin, if anything to add to that, go right ahead.
You did a beautiful job. Thank you.
Thanks. I also saw a question somebody had about public-private partnerships, like a private university that may have a state licensure program. That's another really good question. And we always advocate for open records laws to be construed broadly when it comes to who's swept up in them. We don't think government should be able to hide behind private institutions to avoid the sweep of these laws. Like Erin was saying before, government employees using private listservs and private cell phones and whatnot to avoid their messages being disclosed. We think courts will see through that, and it's not okay. But it really does depend on kind of like public universities, right? How the institution was founded, to what extent is the government involved, what is the which organizations, employees are working on it. And usually you can specifically narrow your request to only target that information that is part of the private-public partnership. So if you're trying to FOIA a private college that has a like a public department in it, for example, I believe Cornell actually is like a collection of a bunch of different schools, different colleges, and some of them are public, some of them are private. So instead of sending the Cornell, you send just the Department of Agriculture at Cornell, which may be public and not really request the records of the administration, which might be private. So there is ways you can research that and figure out how your request can get into the right hands and be responded to.
Thank you. Okay, we've got, we've hit that point where transition from, oh good, we'll have just enough questions to get us through to the end, to realizing, oh darn, they keep coming in, and we have 7 or 8 more minutes left, but we'll do our best. And I've seen one caught my eye, and it's something that I've given some thought to, definitely. Question is, I have seen that a university wanted access to all postings and recordings of faculty teaching online made through a third-party platform, this is something that I am not sure it raises public records concerns per se, but it is something that I know we have paid attention to, and I know organizations like the AAUP have raised concerns about, especially as during COVID, when we were doing so much of our instruction remotely through third-party platforms, what kind of concerns that raised for the intellectual property interest faculty had in their own teaching, and whether it really was even theirs anymore. Erin, I as a practitioner, I'd love to hear your thoughts on that overall issue.
Well, some of this will be determined by the contracts we sign to become employees. Some places we have to agree that what otherwise would be our intellectual property is the university's intellectual property, especially when it comes to teaching. So once that material is deemed to be their intellectual property, I don't know how they wouldn't have a right to it.
Zach, anything that makes good sense to me? Zach, anything more on top of that?
Yeah, I mean, these open records laws are very much very broad. I guess pronunciation is saying all records are public, everything you want you can get, and then a series of a very long list of exceptions that vary state by state. So it really just depends on how the exceptions come into play, and whether it's for intellectual property, whether it's for like Erin was saying, private employee information. And a lot of the analysis here is figuring out how the exceptions interplay with the broad gist of the law, and also how courts interpret these exceptions based on the interests that are asserted in litigation, whether it's privacy, academic freedom, intellectual property, whatnot, and what have you.
Thank you. Okay, I'm gonna still got a few on the board. Let me see, Erin, I see you typing a response to a question we had on electronic submissions of records requests and what kind of costs that might create. Zach, I wonder, this is a question for both of you, but I know it's something that we encounter every once in a while. Zach, when it comes to our use of public records, do you have a sense of how often we fight them on the price that they try to extract for it, and advice for anyone else who worries they're getting gouged on the cost of the public records?
Yeah, it's a really interesting issue because all of our requests have a standard boilerplate paragraph saying that these requests are the matter of public interest in terms of constitutional rights and free speech in universities. And because of that, please waive your usual fee for this. And sometimes they actually do give us the records for your charge. They give us thousands of pages of records, which requires dozens of hours of work for trained professionals across the university. And they give us the records, which is great. Other times they say, thanks, but no thanks. We're going to charge you the full extent of the cost of these records, which could be up to the tens of thousands of dollars, high five figures sometimes, when it comes to getting all the information. And at that point, we try to get the request narrow. We try to, let the university know that we don't want to waste, thousands of hours of their time here to just get perhaps 1 or 2 pages that we're looking for. So I'd say it's around 50-50. The university want to work with us. The university understand that we're a nonprofit. We're trying to get this information, not to harass anybody, but to help our students and professors who we're working with. And other universities, to them, it's a formulaic approach. Wherever they get records, they give them the costs and they kind of put the ball in our court to do something about that, whether it's a narrow request or go to the AG or to figure something out from there.
Thank you. We've had a question outstanding for a little bit, and I don't know how good a job I can do answering this particular question, having to do with investigations relating to the Catholic Church, which has been, a big, one of the big journalistic endeavors of the century, really. But I think that there's a broader question that leads to, and that's something that we do have some experience with at FIRE, which is, how you get the records and communications of private, how the records of private institutions can become public. And I know, and I'm thinking of cases, Zach, like what we had at at RPI, where the institution, which is, long been, in FIRE's experience, one of the worst offenders of student free speech and due process rights, in the last several years. And RPI being a private institution is sort of a black box when it comes to its records, but you can learn a lot about it by going for the interactions it has with public agencies. In particular, when it came to us, the police department of the city of Troy, New York, which had quite the file that we were able to get through our public records request. I'm probably not getting that history completely right, but maybe Zach, could you
totally
fill in some of the blanks on that?
Yeah, it's really funny. A lot of universities will not give us what we want until we just FOIA the police departments, which give us exactly what we want. Because unlike the universities, they don't really have any interest in their in protecting their files. So yeah, that's a technique we use. We work with police departments, we FOIA their records, and we try to get what the universities can give us. For other institutions, I'm not universities, though. I defer to Erin. I'm not a journalist. I'm just a First Amendment attorney. I wasn't trained in how to get this information and whatnot, but I know I'm sure there are techniques that can be done to get these files from these big private organizations like the Catholic Church.
I think it depends on what you're looking for. And there might be other types of public records that would be easier to obtain this information from. A lot of times we start with people and just keep building our network through conversations for who is generous enough to share information with us as well. But I have an article coming out soon that addresses a really sensitive topic, looking at when survivors of sexual assault or rape may have their identities shielded by law or not shielded by law. And through that research, I've come across a number of cases that addressed people trying to access material from law enforcement that addressed specific cases of abuse from priests in the Catholic Church. And those cases have varied a lot in terms of what types of information may be publicly available and what types of information may be shielded under privacy exemptions.
Great. Well, we're officially into bonus time. It's really flown by. So I unfortunately don't have time to take more questions. But if you take a look at the chat, I've given all of our emails for myself, for Zach, and for Erin. I just want to say, Zach and Erin, this has been a tremendously informative session for me, and I hope for the rest of our faculty network attendees. And I just wanted to say thanks very much for me to both of you. Is there quickly any parting thoughts or parting advice you might have for those with us today?
I want to say thank you, Peter, for organizing this, and thanks Erin for being on this panel with me and talking about these issues. As people in this chat, I'm sure know, if you face any violation of your academic freedom rights, your free speech rights, feel free to contact FIRE. We're here for you. And my email address, zach.greenberg@fire.org, is right there in the chat. Any more follow-up questions, discussion, anything you have about this issue, we'd love to hear from you. This is my job. I love it. It's the best job I've ever had. And it's really an honor to speak to you all today.
All right. Well, and Erin, anything more for you?
Thank you very much for your interest in this very important topic, and thank you for the opportunity to address it. Please feel free to email me questions. Again, I'm not a lawyer. I can't give you legal advice, but I can tell you what I've found through my research and send you some case citations. Thank you very much.
Great. Thanks, everyone. Have a great rest of your day. And we'll hopefully have this recording up on our website in a few days for anyone who wants to reference it, or share it with your friends, share it with your colleagues, share it with anyone who wasn't able to make it today. So thanks, everyone, very much. Take care, and we'll see you again soon.